Good evening. This is Making the Case. I'm Yodit Tewolde. All eyes are on Brunswick, Georgia tonight. Opening statements began in the trial of three white men, Gregory McMichael, Travis McMichael, and William Roddie Bryan, all charged with the murder of Ahmaud Arbery, a 25-year-old black man. Arbery was shot and killed in February 2020 as he was jogging down a residential street after being chased by the defendants. BNC's Drake Clark is in Brunswick with the latest.
It was a long day for jurors who had to sit and listen to several opening statements, but the more emotional time was when they saw video of Ahmaud Arbery just minutes after he was shot and killed, his body lying in the middle of the street, covered in blood. Prosecutors maintained that the three defendants wrongfully assumed that Ahmaud Arbery was a dangerous burglar, while on the other side, the defendants say they acted in self-defense.
Mr. Arbery ran away.
Linda Dunikowski told jurors Ahmaud Arbery was under attack when he was shot and killed February 2020. She told jurors the defendants, Greg and Travis McMichael, along with William Bryan, assumed the worst about Arbery when they saw him running through their neighborhood. She said they chased Arbery for 5 minutes, eventually trapping him with their pickup trucks.
How do you know this was an attack on Mr. Arbery? Because Greg McMichael said it perfectly. Mr. Arbery was trapped like a rat.
And then she said Travis McMichael shot and killed Arbery with a 12-gauge shotgun. The entire shooting captured on cell phone video. Arbery's mother cried out loud, seeing the entire video of her son's death for the first time in court.
I thought it was time to get familiar with what happened to Ahmaud. I'm the last minutes of his life, so I'm glad I was able to stay strong and stay in there.
Video of the shooting wasn't released until 3 months after it happened. Travis McMichael's lawyer told jurors he was protecting his family and the community going after Arbery. He said there had been a rash of burglaries in the neighborhood, and Arbery had been seen on security video late at night walking inside a home that was under construction. McMichael, he said, feared for his life when he pulled the trigger.
It's tragic. It's tragic that Ahmaud Arbery lost his life. But at that point, Travis McMichael is acting in self-defense.
Gregory McMichael's lawyer said when he saw Arbery running, he immediately knew it was the neighborhood burglary suspect, and the retired law enforcement officer was going to make a citizen's arrest. William Bryan joined the chase, and investigators say knocked Arbery into a ditch with his truck. All three men have pleaded not guilty to all charges, including murder. But if they're convicted, they could spend the rest of their lives in prison. Prosecutors say although Ahmaud Arbery had been seen on security video several times walking around inside that home that was still under construction, they say the homeowner never reported anything being stolen from the home. And that's why they maintain the defendants wrongfully assumed that Ahmaud Arbery was a suspect or even armed and dangerous. In Brunswick, Georgia, I'm Drake Clark for Making the Case.
Tonight, my legal panel of experts are ready to weigh in on day one of the guilt-innocence phase of this trial. We've got veteran prosecutor and BNC's legal contributor Paul Henderson and criminal defense attorney Darryl Exum. Counselors, great having both of you on tonight, but there's a lot to cover, so I'd like to get right into it. Opening statements. This is an opportunity, right, for lawyers on both sides to draw the jury's attention to evidence they expect to introduce. They're introducing their theories of the case and point out the gaps in evidence. So how both sides address the jury in opening statements sets a tone for their respective cases. The state goes first. They have the burden of proof. So lead prosecutor Linda Dunikowski, she started off by describing the events of February 23rd, both before and after Ahmaud was killed. Take a listen.
Mr. Arbery ran away from them for 5 minutes, up and down Burford. Then 4 times Mr. Bryan tries to hit him with his pickup truck. How do you know this was an attack on Mr. Arbery? Because Greg McMichael said it perfectly. Mr. Arbery was trapped like a rat. That's what he told the police.
Paul, we all knew what the defense was going to say in their opening statements. And obviously, so did the prosecution. So right out the gate, Ms. Dunikowski tries to take steam out of any self-defense claims by telling the jury it was Ahmaud who was under attack. Was this the most effective way for the prosecution to start?
I think it was effective. I would have questioned and challenged the delivery a little bit had it been one of my lawyers or in my case. You know, I always want to see more emotion, specifically in a case like this, to make sure that they convey that they really understand, that they really make the point. And that to me is where, you know, it makes a difference, I think, in influencing jurors who are paying attention to understand how the advocates understand the evidence. And so to the degree that the defendant in this case has said that the victim was trapped like a rat, I would have emphasized that a little bit more. I would have made sure that they understood, knew, and drew the connection on how significant it was that he made that statement, specifically to countereffect the defense's presentation that they were going to bring about it being self-defense, which is what we had already anticipated based on the charges and based on what the defendants had already said in their statements.
Darryl, your thoughts?
You know, I guess the prosecution, I thought, did a pretty good job, in my opinion, in terms of how they countered the defense. But I think that what really struck me in this case is that how the prosecution really didn't, you know, to Paul's credit, and I agree with him, they really didn't give an emotional sort of position. I mean, this is one of the biggest cases sort of in recent memory. And what happened in this case was a man thought he was going to get killed, and he was killed. And I just didn't hear that from the prosecution. And it made me just a little uneasy.
Well, you know what else I noticed too, and I'm always looking for this with the prosecution's case, is to have a photo of the victim, right? In order to humanize them, because they're going to play some really, I mean, they're going to play this video that obviously, you know, shows his tragic killing. But when you have this description of by the defense that this, you know, that they trapped a rat, you have visuals of him bleeding. It's nice to actually have a visual of just to humanize him. And so I think that that's a missed opportunity as well on the part of the prosecution. All right, another key moment in the prosecution's opening statements came when they introduced the most powerful piece of evidence they have against these defendants, courtesy of Mr. William Bryan, the video recording of Ahmaud's killing that everyone has watched at least once before this trial began, some of the jurors included. However, this time the prosecutor paused the video periodically to walk the jury through exactly what they were seeing. Here's a portion of that moment now.
Mr. Arbery is under attack by all three of these men. He's under attack. Because that doesn't stop Mr. Bryan that he went into the ditch. Mr. Bryan tries to hit Mr. Arbery 1, 2, 3, 4 different times with his pickup truck. 4 different times with his pickup truck. Mr. Arbery is under attack.
Darryl, when there's evidence in the form of a video that prosecutors can take frame by frame along with a narration, burning into the minds of these jurors the most damning parts for the defense, it's hard to recover. Clearly an effective strategy on the part of the prosecution by introducing the video this early on in the trial, but knowing it'll be played several more times throughout the state's case, how does the defense take the sting out?
You know, the best thing that the defense can do in a case like that where there is a video is themselves to present an alternate view of the video in opening statement. And I think that was, listen, if you look at it from a defense perspective, the defense seems to be, they seem to be drowning early on because they're not attacking the evidence as it sits. I mean, the video is the most damning evidence. And from a defense perspective, they should have played it and explained it in a way that countered the way the prosecution was doing it. Because otherwise, I mean, the interesting thing about this case is not about the law of stand your ground. This case is about vigilantism and what vigilantes do. That's what this case is about. And the prosecution seems to get that, but I don't get the a distinct opinion that the defense seems to get that.
Well, members of Ahmaud Arbery's family, including his mother, Wanda Cooper Jones, was present in the courtroom today. At one point, Miss Cooper Jones was seen visibly emotional watching the video. Afterwards, she described what today was like for her. Listen.
I decided to remain in so I can get familiar with what happened to Ahmaud the last minutes of his life. I've watched the video for the last 18 months, and I thought it was time to get familiar with what happened to Ahmaud. The last minutes of his life. So I'm glad I was able to stay strong and stay in there.
Paul, what impact does the family's presence in court for either side have on the jury?
I think it's really powerful, and had that been me in that moment, I would have paused to stop, to look, to react, to make sure that I had a reaction as well, because I, as a prosecutor, am the representative for that family. I, as a prosecutor, am a representative for the people. I, as that prosecutor, would have been a representative for the community in that courtroom. And so I think when you have moments like this, you have to take advantage of them as a smart lawyer. You have to be watching and paying attention, not just to the jury, not just to the defense counsel and what they're doing at their table and the defendants, but to the audience as well. That includes the folks that are out there around you and the judge. Having these moments like this that we all saw recorded, that this country all saw recorded, and this was a powerful moment, I think was probably powerful for that jury, and I didn't want it to just pass. As we are having this conversation and talking about it, I think that's a moment for the juries to see that the person that is not in the courtroom is someone that was killed, someone that was murdered, someone that had a family, someone that was cared for, someone that stands for and represents a travesty and a crime that was committed. And all of that was in that moment. That's what I took from it, and that's how I would have reacted and responded.
All right, guys, we're coming up on a break, but Paul, Darryl, there's so much more we could discuss, but we still haven't even talked about the defense's opening statements, so we'll get to those when we come back. More Making the Case after this. Day one of the guilt-innocence phase in the murder trial of Gregory McMichael, Travis McMichael, and William Bryan began today with opening statements from both sides. My legal panel of experts are still with me, veteran prosecutor and BNC's legal contributor Paul Henderson and criminal defense attorney Darryl Exum. All right, guys, now to the defense's opening statements, starting with the first one given by Robert Rubin, the attorney representing Travis McMichael, who portrayed his client as a man who felt he had a, quote, duty to protect his neighborhood, someone who had reason to believe that Ahmaud had committed a crime, and also as someone who had no choice but to shoot Ahmaud in self-defense. Take a listen.
Travis is trying to get the gun away, and Travis fires 2 more times, and you've seen that. It's a horrible, horrible video, and it's tragic. It's tragic that Ahmaud Arbery lost his life. But at that point, Travis McMichael is acting in self-defense.
Darryl, for self-defense to stick, the defense is going to have to convince this jury of 2 main things, right? One, that the McMichaels were attempting to make a lawful citizen's arrest, and 2, that they had a reasonable belief, and reasonableness is up for the jury to decide, had a reasonable belief that they were either going to die or be seriously injured. Do you think Mr. Rubin's account from his client's perspective of that day was convincing enough to raise a doubt or 2 in the mind of at least one of these jurors?
I was a little perplexed at why he didn't at least add more facts to what he was saying, because Georgia has the law that, you can't create the situation where you use self-defense. So the problem here is that even though there is the stand your ground law, by bringing a shotgun to this situation, they've in essence created the facts of self-defense, because the Arbery is in a position where he's confronted by a person with a shotgun. He doesn't have a weapon, and their position is he had a weapon or he was going to reach for a weapon. And the problem with that, of course, is we know that's not true, but let's step back for a second. You're confronted either with a person who is a gun, you either turn or you fight. And the prosecution, that may be their greatest point that they said in their opening statement, that he either had to fight or he had to turn his back on a person with a shotgun. And I just think the way they stated it, self-defense won't work.
When you are the initial aggressor. Paul, your thoughts?
Okay, there's a lot to unpack here, and I will say this was another day that I spent probably how most people spend watching sports, screaming at the television and yelling out loud. And the opening statement from defense was particularly hard for me. I felt angered, I felt offended, and I just want to point out a couple of things that really stood out to me, and I love how you framed it, outlining the terms that they used and the tone that they approached this. But it felt insulting to me that they have tried to use an adoptive admission that is so negative for Ahmaud Arbery, who is the victim in this case, and how they framed almost the savior approach that the defendants had in their behavior in actually killing a man. Some of the terms, and I was writing furiously as if I were in trial for this case, writing down their exact terminology, saying that that his client had a duty to protect Larry English's property. Did he have a duty? Who determined that? I wanted to hear objections from the prosecution, as the prosecution was interrupted over and over with ridiculous things. And that was a whole distraction from the court, which I think was their counter because they didn't have a video. I wanted to hear prosecution standing up for these misinterpretations of the law that defense counsel was trying to feed to the jury to try and give them an adoptive lens to watch the video in a way that was most favorable to the defense, but also absolutely wrong. The way that they talked about Ahmaud in the case, saying that he had the audacity to take actions the way that he did by walking through the neighborhood, but that was an audacity to go into someone's house, which they didn't say that other people had been in the house as well, and that it had not been a problem. The way that they talked about his scary presence, that's a quote that they used about him. What was scary about him being in that neighborhood, other than being black and being there, other than that was what the defendants wanted you to believe, that he was plundering. He was not plundering, and they referenced plundering 2 or 3 times. He was just there. He was running away from them, these armed men. And even with the armed confrontation, the language that defense attorneys used with the jury for their opening was, it really was offensive. They said that they were hoping to de-escalate the situation and confrontation by pointing a gun at Ahmaud Arbery, and that he ran at them. They forgot to say that they had cornered him to point the gun. It just, there's so much here, Yodit, that it really bothers me.
There is.
I'm just upset.
But listen,
about it.
I want to get into another moment that was sort of a rare occurrence. I'm going to skip over Franklin Hoag's opening statements because I wasn't impressed, so I'm going to go straight into the issue with the attorney representing William Bryan, Kevin Gow. He told the judge that he wanted to reserve giving his opening statement until after the prosecution presented its case. While the judge described the strategy as unusual and one that he's never seen in his decade on the bench, he granted Gow's request. Let's take a quick listen to that exchange.
I'll tell you, Mr. Goff, I've been doing this for almost a decade, and this is the first time counsel has asked for that. Let me look at what the rule that you're trying to act under and the ABA standards that you're talking about. What you're asking the court, though, is to reserve until the state's case in chief has concluded.
Yes, we have the right to do that under 10.2. It was not always clear, but it became clear.
Darryl, in some states, the defense can, in fact, wait to give their opening after the state's case in chief. It's a rare move, and I'm guessing that's because the defendant doesn't really benefit much from reserving. Isn't it true that jurors usually come to a decision about guilt during or immediately after opening statements? I mean, why run the risk of saying absolutely nothing at the beginning, but then wait until after the prosecution presents all of their damning evidence against you?
You know, there's a rationale and there's a reason why you might do that in a case. And, you know, honestly, in a case where there's multiple defendants, a jury's going to want to hear from you. They're going to want to hear from you. The problem that I have with him doing it in this case is it would be different if there were two awesome opening statements that laid out the evidence and painted a picture consistent with guilt. They gave facts consistent with innocence, but they didn't. So he, in essence, did exactly what you said. He really just gave away his first opportunity for the jurors to make a decision in his favor, and rightfully so, because in this case, the biggest problem will be that the jurors will make a decision early on. And I think the prosecution's opening statement was damning. And the two defense attorneys didn't really counter it enough. So for me, as a defense attorney, I would not have ever, in this case, waived or reserved opening. I think when you look at the judge looks at this and says, I really don't understand why you would do that. I mean, right. It's so just a strange thing in this case.
All right, guys, I'm keeping you just a little longer to weigh in on the first witness the prosecution called to the stand. Stay tuned for more Making the Case. Welcome back. Still with me, BNC's legal contributor Paul Henderson and criminal defense attorney Darryl Exum. All right, guys, so the first witness the prosecution called was police officer William Duggan. He was one of the officers to respond after the shooting took place. In addition to hearing his testimony, jurors were also shown body cam footage taken from the moments he arrived to the scene. Here's him recounting what he saw.
I did see a black male laying on the ground in the middle of the roadway on the pavement. There were a couple of other people walking around, milling around. There was a vehicle in the road further back past the person that was down on the ground.
Darryl, usually, you want to start with a bang, you want to end with a bang, right? So you want to put your strongest witness up first. I'm not necessarily sure that this was it or he was it. Do you think the prosecution is just essentially presenting their witnesses in accordance to the order in which everything sort of unfolded on February 23rd of last year?
Yeah, I agree. It's primacy and recency, and I think what the prosecution did in this situation was they're trying to go chronologically, and I don't know if that's necessarily the right thing, but that's obviously what they're trying to do.
Paul?
Okay, so here's the thing. I really did not like that as a first witness. I wanted the story, I wanted the narrative, I wanted to hear about Ahmaud. I didn't want to hear about a black male on the street. I wanted you to get one of those witnesses, some of the neighborhood people that saw a black bleeding body laying in the street, to tie that narrative to a real victim, to tie that narrative to someone who died because of the actions of those defendants, and not a sanitized interpretation using cop talk of what happened. I get that that's part of the narrative, but I wanted something to swing it home from the opening statement, to tie that narrative to real people in the audience that could have been white, could have been black, to talk about what they saw and what they observed, and then build out the narrative. That's what I would have done. I mean, we have to have the conversation about that being in the courtroom is still part of theater as well. You have to build your narrative in a way that's persuasive, and I wanted a little bit more from the prosecution with this witness, the first witness to take the stand.
Okay, I really want to get this last question in. I'm running out of time. I got 90 seconds, but I really want to get your take. The issue of face masks came up from the defense, making the argument that the jury had a legal right to see the faces of those involved in this trial. Do they have a point? Darryl, you first.
Absolutely, they have a point. Seeing someone's face, you get a full vision of what that person is doing and who that person is, and the facial expressions that they make help you determine whether or not they're being truthful.
Paul, quick.
Yes, but I would have pointed out the witnesses that I wanted them to pay attention to. I would have planted that in responding to it to make sure that the jurors hear that I want them to pay attention to the face and the presentation from the witnesses that I'm going to call.
All right, Paul Henderson, that was great, Paul. Thank you. You were quick there. Paul Henderson, Darryl Exum, thank you both for your time and insight tonight. All right, guys, remember, we're your go-to for the latest developments and expert analysis on this trial, so tune in every weeknight right here on Making the Case.